We have a quorum, and it's now time we should start the meeting. Let's invite the officials in. Subcommittee on Subsidiary legislation made under the new Companies Ordinance CO. This is our 9th meeting. Save time, I'm not going to introduce the government officials with us today one by one. There are nameplates in front of them. At the meeting on June 11th, the subcommittee has already finished the clause-by-clause scrutiny of company records inspection and provision of copies regulation and companies non-Hong Kong companies regulation. Upon request of members, the administration has supplied paper CB-11341-1213-02 to follow on matters arising from the above regulations. I'll invite the administration to take us through this paper. And after that, there are still two regulations for scrutiny. The LN 80 and LN 70. I think the first one is simpler, which is about the company's fees regulation. So we will discuss that first, and after that we'll come to the discussion of LN 77. Mr. Yu, will you take us through the paper on matters arising from the previous meeting? Thank you, Chairman. At the previous meeting, members scrutinized two regulations, one on companies' records and the other one on companies non-Hong Kong companies' regulations. For the one on company records inspections and provision of copies regulation, members made suggestion on that, which is to extend the time given to company to submit records from 5 business days to 10 business days. We are ready to respond to the request, and we propose to change the period from 5 business days to 10 business days. And it's also stated in the proposed regulation. The second regulation is about proposed amendments on Chinese text. We consider the request and we propose to make amendments to the Chinese text is purely on the Chinese text, and the meaning of the law is not changed. Any views? Understand the administration take on board all our suggestions raised at the previous meeting. There's no comment. Let's move on to LN 80, which is companies' fees regulation. Mr. Yu. Thank you, Chairman. Our goal is to respond to the new CO. We have to make available relevant subsidiary legislation. About fees to be paid to the registrar. The fees in Schedule 8 will be incorporated in the new regulation. For the fees and the levels proposed, there is no changes to the payees. There's just one thing new, which is about the fees for companies limited by guarantee to pay. At present, there is a flat rate for these companies, whether they submit the information early or late. However, for companies limited by shares, since 1988, they have been paying escalating scale for late filing. So we want to make things consistent for these two kinds of companies. Under Schedule 1, Part 2, the escalating scale level is set down, and the level is the same for companies limited by guarantee and companies limited by shares. Schedule 1 is about the fees payable to registrar in relation to registration of a company or for registration of documents delivered, and Schedule 2, fees payable to registrar for inspecting or obtaining documents or information on companies register. Schedule 3, fees payable for obtaining registrar's approval or license, and Schedule 4, miscellaneous fees. They are the same as the present ordinance, so I'm not going to details how now. So basically, there's no change except for one point. That is, the fees for late filing will be the same for companies limited by guarantee and companies limited by shares. Any views from members? Mr. Sin Chung Kai. Mr. Sin, are you reading it? Ms. Chang. Chairman, it seems there's no major changes except for the fees. May I ask the administration to tell us whether there are points that may lead to some reactions? For example, people may think the fees may be too high. Any possible complaints? Mr. Yu? As at present, this subcommittee has not received any special views from other parties about the fees, because the fees has been in existence for a long time. This morning, we received submission from Hong Kong Institute of Directors. They sent us an email this morning, and the Institute has no comment on the fees. Email just tabled. We only received the email this morning, so they don't have views on this point. Can I take it there's no changes? Except for one, that is the fees, the level of the fees are made consistent. In the past, there is a difference in terms of level for companies limited by shares and by guarantees. Chairman, for companies limited by shares, they have to pay escalating scale. But we now make things in line for two kinds of companies.
Understood. Oh, okay, nothing, okay. Now, if there are questions, we can still raise them later on. Now we go to Notice 77. Thank you, Chairman. Now, this is the model articles notice. Now, the effect of the notice is that there is now a model for companies that they can adopt. When a company is established, the company can decide about its own M&A. Now, if it feels that the model articles are applicable, they can choose to adopt the model or part of the model or none of it. So the actual legal effect is not binding. It's to supply a model for good governance, and the company can take into account its own circumstances and adopt it or not. Now, the other point is that right now, existing companies already have their own articles. They can use the existing Schedule A. So the model articles do not affect them. This applies only for companies to be established in the future. They may have the option. So the existing articles will not be affected by this notice for existing companies. But if they feel that the model articles are useful, then they can adopt them by their own procedures, amend their own articles. Mr. Andrew Leung, the old Company Ordinance, does it have a model set of clauses? Yes, that's in Schedule A for companies limited by shares. It's similar to a set of model articles. Now, the arrangement is the same. The company can decide whether to adopt all, part, or none of Schedule A. This is entirely for the company to decide. So the old Schedule A, how does it differ from our model articles now? Now, firstly, there are some minor changes. Firstly, in terms of format concerning public companies and private companies, because they operate differently. So for convenience, we divide companies limited by shares into two categories and have two different sets of models. So the set applicable to public companies is longer. Now, as for Schedule 2, that's for private companies, is simpler because the operations are more simple. As for Schedule 3, it's companies limited by guarantees. Now, compared with private companies limited by shares, there are some changes. For instance, for companies limited by shares where there are dividends or there are sales, now these don't apply to Schedule 3. So in the notice, we have different schedules for different types of companies. This is for the convenience of companies. As for companies limited by shares and how it's different from the existing Schedule A, I will ask my colleague to explain it. Will it be Miss Francis Sid or someone else?
As Mr. Yu has indicated, drafting of the articles, they're simpler, they're more coherent, we've structured them differently, they're in a different format. But essentially, the basis of the regulations that we're putting in the schedules to the model article notice are the same as the provisions in Table A, but they're clarified, modified, more coherent, easier to understand. There are just a few that we have omitted altogether that will not appear in our model articles, and these are, for example, Articles 41 to 44 of Table A, which is about conversion of shares into stock. And that is purely because we have removed the power to convert shares into stock in the primary legislation. Section 138 of the new CO, that power has gone. Also, the borrowing powers that are contained in Article 81 of Table A, they are not reenacted on the basis that a company has all the powers of a natural person anyway, so there's no need for them to have these distinct powers in Table A. Also, the provisions relating to the duty to keep accounts, there's provisions relating to that in Table A which have not been reenacted because that again is now provided clearly in the new CO. We have distinct provisions, Part 9, Section 373 onwards, about keeping accounts, the duties of the directors, and also audit requirements. There's an Article 131 in Table A that's not been reenacted because again that's now a clear statutory requirement under 394. The majority of the other Table A articles do appear, albeit in perhaps a different, more simplistic form, hopefully more coherent, easier to understand, but they are modelled for the most part on the current regulations.
我諗主席我明白啦，即係公眾公司用另外一個方法處理係冇問題啦，同埋
And that you use a different way to handle the public companies, and they are listed. The SEC will look at them. So the companies limited by guarantees are a different thing. So the administration said that some things are deleted because some appear in other legislation. So we don't have to go through it clause by clause. What is added? What has been added apart from the format, apart from the interpretation? Are there now, for what's deleted, we don't have to take care of them. But what has been added? What has been new, Mr. Yu?
We have added specific provisions relating to alternate directors, which I think is something that has been welcomed on consultation. This was something that was welcomed. Initially, we put the provisions for alternate directors only in the public company schedule. But after consultation, it was considered that this was useful for all Hong Kong companies. So we've got provisions for alternate directors in the 3 schedules. We've also got written resolutions for directors. We've got specific provisions relating to the procedure and the process for public companies. That is in the new schedule. Apart from that, really, the majority of the other provisions have been modified because of new requirements in the CO, but there really isn't anything drastically new or dramatically new other than these initiatives that we've tried to accommodate what people want in the schedules.
Any question?
No questions. Mr. Lee Ting-kwong, I'd like to ask about operations. Now, just now, Mr. Yu was right that the former Table A companies can decide to adopt them, or they can have their own. Of course, they have to meet with company legislation, or you can adopt part of it, or you can modify the Schedule A. Now, I'd like to ask about the new model articles. Operationally, is it the same as before? The companies can choose to adopt them, or they can make up their own, provided it's in accordance with the law. They can also modify the model articles. Is it just like before? Is it identical as before? Yes, identical as before. The company has total discretion to adopt the model articles in whole, in part, or not at all. Now, understand the model articles is just to facilitate people. Yes, that's correct. Mr. Sid, for those who are not familiar with Schedule A, now, what's the legal implication of having model articles? Now, they have to register their own articles anyway, right? So why is it that in the legislation there are these model articles? Is it that the company's registry feels that you have something for people to copy from? Why is it inside the company's legislation? Mr. Yu? As I said, every company must have articles. So we hope to provide model articles as basis for their consideration, and we deal with it through a notice. So if a company doesn't have its own articles when it's established, it can choose to do so. It doesn't have to submit any. In that case, by default, the model articles would be adopted. So this is done through the notice. So how does a company register? It doesn't have to submit its own articles. It just fully adopts the model articles, and just the directors fill out the forms. Mr. Sin, now some accountants and law firms, they have shells that are registered already, shells of limited companies. So the articles follow the model. So if you buy the shell companies, you just add certain provisions, and then voila, you are done. The chairman is correct. If someone wants to establish a company, of course the law is very clear. It has to submit articles. But if for certain reasons it feels that the company doesn't need to draw up its own articles, then given the notice will apply to them. So if it's entirely blank, then the model articles will apply. Now, operationally, when a company is established, if it's done electronically, then the system would require the company to upload its articles. So it will be faced with a clear decision to either use its own articles or to use the model. So if a company is established without articles, now that's very unlikely. But if it doesn't have articles of its own, then the model articles will apply to that company. Any question for follow-up? Any other questions? Our legal advisor, Ms. Low, any question? Thank you, Chairman. In the articles, as I understand it, the administration basically adopts the articles in use in the UK. Now, previously, there are some that are not in Table A but are inserted as new provisions. Now, perhaps there are one or two points that I can raise for members' reference. For instance, there's one point that is convening directors' meetings. There it mentioned that if a directors' meeting is convened, a notice has to be served, and there is an existing provision in subsidiary legislation that is, if the notice was not served and after the event the director who did not receive the notice, it can forego giving the right to receive the notice, and if exercises that right, to forego the notice, then during the directors' meeting, the matters dealt with will not become effective. But there is no provision saying that if it doesn't forego his right within 7 days, then what will happen? Now, the existing subsidiary legislation doesn't mention this, so the company may then have to decide on its own. This is the first point. Now, if members are looking at the Gazette, that is B on page B221. Part 1. B2221. This is Article 7 of Schedule 1. LN 77. of 2013 notice. Schedule 1, Article 7, bracket 6, concerning calling directors' meetings. Now, under bracket 6, the provision says that if the director hasn't received the notice and a directors' meeting is called, then within 7 days, he can inform the directors' meeting that he gives up the right and the matters dealt with will be effective. So this notice says even if no notice is received, it's still effective. Now, for members' information, now if he hasn't taken the step to give up the right, then what will happen? Then that will be up to the directors of the company to decide. Now, Mr. Yu, if it is according to the legal advisor, and if I understand correctly, if there is no notice of 7 days, then the meeting becomes ineffective. Yes, unless notice is given in 7 days that he agrees with the matters decided, otherwise the resolutions are ineffective. Is that right? Now, I will answer briefly and then my colleagues may supplement if necessary. Now, under Article 6, now directors can make decisions either within the directors' meeting or by written resolution. Now, if the directors' meeting in terms of notice, if there's a problem with the notice and someone raises a query or launches a legal challenge. Now, if there are 3 directors and one director said he took part in the meeting, but the other 2 directors have not received notice, then the other directors can raise a query. And bracket 6 deals with the situation, for instance, if the notice has not been served to certain directors, but the director does not query the decisions in the meeting, then here is a way for the director to waive his entitlement to the notice so that the matter is clarified. So he gives up the right to be notified, so the matter handled doesn't have to be queried or to be decided anew. So this is a simple way for a company to deal with an irregularity. But if a director wants to raise a query, then if necessary, it may have to go to the court, and the court will look at the whole set of circumstances. Let me follow up. This is Part 2, 7, bracket 6. So if a director or certain directors, in the absence of notice, the directors' meeting was held and the resolutions are not queried, then there would be the opportunity for the matters decided to become effective. Now,
of course, it will be altogether a different matter if there are disputes. Is that right? Yes, that's correct. Mr. Martinell, is that what you meant? Yes. Legal advisor, any other questions from you? Thank you, Chairman. Second point. The administration also mentioned about the alternate director, and in Chinese it's called 候补董事. In Schedule A in the past, there was no provision on alternate directors. Let's look at LN77 and B2225. There are from Article 30 onwards, there are provisions about alternate directors. I want to mention one point. In Article 31, and the page number is B2247, 31.3. It says that an alternate director can be an incumbent director. And by the consent of the board of directors, an alternate director can be a non-incumbent director. And in Article 31.3, it says that a person who is an alternate director but not a director (3A and B) is about he may be counted as participating for determining whether a quorum is participating. And if it is the decision is made by written resolution, then if the person's appointed has not signed the written resolution, he may also sign that written resolution. And Article 31, bracket 4, it says, no alternate director may be counted as more than one director for the purposes mentioned in paragraph 3. Now, there is this one scenario. A non-director is appointed as an alternate director, and he may be appointed, say, by more than one directors as the alternate director. So in counting the quorum and in signing the written resolution, he may not represent more than one director to do so. And if he does so, he would be just counted as one in number. Now, if we look at the Article 18 on written resolutions, what is counted or adopted as directors' written resolutions
a written resolution is adopted when all the directors who would have been entitled to vote on the resolution at a directors' meeting have signed one or more copies of the written resolution. So in that case, if a non-director is appointed as an alternate director by more than one director, say if he is the alternate director for number 1, 2, or 3 directors, what he signs cannot be adopted because that can't be satisfied Article 18.1 in the schedule, because he can't be counted as 2 in number. So this is something for members' consideration reference. Well, I'm just contemplating what you said. I'm a little bit confused by what you said. Now, if you have been appointed a director, how can you be appointed as an alternate director? I'll try to explain a bit. Say if 3 of us are directors, Mr. Sin and I can't attend the meeting for whatever reasons, and maybe we have to go traveling or to study for 2 months, and then I appoint you as our alternate director, and you are also a director yourself. Now, for the quorum purpose and for signing the written resolution, you can't represent the 2 of us because you can only represent 1 person. So for signing a written resolution, you can just represent 1 more director apart from yourself. You can't represent 2 directors. So you can be the alternate directors for a number of directors, but for counting purpose, you can only be 1, represent 1. Oh, it just works the way as proxies work. So if, say, 2 board members or 2 directors appoint me as an alternate director, I can only represent either one of you. All right, is that the case, Mr. Yu? Yes, that's correct. Mr. Martin Leo's understanding is correct. Let me give you some background. We don't want to see the scenario whereby all the directors will appoint the same person as the alternate director. And if the alternate director can represent everybody in signing a written resolution which is valid, then that would not be good. We want to avoid the situation where the same person has been appointed as the alternate director by everyone, and then that would not be a good governance practice. So that's why we want to avoid the scenario where many directors appoint the same person as the alternate director. So for the scenarios that we mentioned, the alternate director can only represent 1 director. Now, say if there are 10 board directors, and then 3 of them appoint this 1 alternate director, he can only represent 1 of them. Because for written resolution, we need every director's signature. So this alternate director can only represent 1 of them in signing the written resolution. So in other words, Chairman, so if there is an alternate director, written resolutions can't be adopted if, say, more than 1 director appoint the same person to be the alternate director. Yes, that's correct. That's a reminder from the legal advisor. Chairman, can I supplement? Perhaps the administration can confirm my understanding. If we look at the articles, the scenario applies to the situation when more than 1 directors appoint a person who is a non-director. Say if the directors appoint an alternate director which is a non-director, then that doesn't apply, right?
the subdivision 4 applies to all directors, not just directors who are non-direct, not just alternates who are non-directors. So no alternate director may be counted as more than one director for the purposes mentioned. So the distinction between not being a director and being a director as an alternate, there is no distinction as regards this particular provision. So the written resolution procedure is, even if you appoint another director, you can't do the written resolution because we want to have the consensus of all. It has to be unanimous. So there has to be independent judgment exercised by each director. That's the situation. And this is modelled on the UK provision.
Members, there are one or two more articles which don't seem to reflect what the administration said. Let's look at Article 31, LN 77. It's page B2247 in the English version and 2246 in the Chinese version. Article 31, bracket 3.
For the purposes of quorum and written resolution, that a non-director can be included. That's why it's necessary to make the distinction in subsection 3 that it is but not a director, because obviously a director would be counted for quorum and does have a right to sign a written resolution anyway. So this is just to make it clear that non-directors also can count for this purpose, for the purposes of quorum and for a written resolution, because they are not directors themselves. So it's necessary to make this distinction in this particular article.
呢個佢係候補董事，但係本身唔係董事，會唔會有另外一條條文呢？佢本身係董事，就被指派為候補董事，就係問題出在呢個。因為佢香港嘅唔可以算作一，佢講緊第三啫嘛，第三淨係講緊情況啲。
主席，如果你睇翻第三。
Chairman, let's look at Article 31.3. The alternate director is just an ordinary member of the public and may not be a director. And if he is a director, that clause should not be applicable. Is that right? The legal advice's query, if he is a director himself, and he is appointed as the alternate director, how should all the counting be done? Well, my understanding is that if he is a director, he can't be appointed an alternate director. Is that right? You can't appoint a director as an alternate director. Is that correct? Well, let's look at the previous page. In the Chinese version, it's B2244, and in English version, it's B2245. 30, bracket 1. A director, bracket appointer, may appoint as an alternate any other director. In other words, if I am a director, I can be appointed an alternate director also. I can also represent you. Well, there are two things here. Alternate director. I think it belongs to another category. If I don't attend the meeting, I will find someone else to attend on my behalf. But then, if I appoint you to represent me, I think it should be a proxy rather than an alternate director. Well, my understanding is that there should not be more than one proxy. Chairman, I'm not sure. Right? Article 31.3 is applicable to a person who is an alternate director and who is not on the board of directors. And according to Article 31.1, if a person appoints another director to be the alternate director, he can be counted as just one person, no matter in counting as for the quorum purpose. And he can sign as one person only any written resolution. Well, then that doesn't work for a written resolution, because in Article 18 it says clearly is that a written resolution should be signed by all directors. So if he is a director, Article 18 together with Article 31(4), then that will bar him from signing the written resolution.
That is the intention, so that there's not too much power in the hands of the alternate. Because the written resolution procedure should really be used when there is no meeting, so there's no opportunity for the minority to persuade the majority. Whereas in a meeting purpose, you can vote and there is the opportunity for discussion. For written resolution, there's no such opportunity. So the idea is that there has to still be this judgment exercised, because the alternate director is beyond a proxy. I think Mr. Leung suggested it was like a proxy, but the proxy is, of course, acting on behalf of the shareholder with his proprietary right. He has to act in accordance with his instructions. The alternate director actually is exercising his own judgment as director, so it's essential that there is some independent mind brought to the decision. And this, as I say, this is based on the UK provision. They consider it really inappropriate for the written resolution procedure. So if it is unanimous, it is going to be that there has been minds that have considered it and agreed that it's an appropriate resolution to pass. So regardless of whether you're a director or another person, it's bringing that independent judgment. That's the intention.
Well, why can't we go down the route of what Mr. Leung suggested? Now, if you are a director and you are appointed an alternate director, first of all, according to 31(4), you can't be counted towards a quorum, and then you can't sign written resolution. Why can't we just bar director from being appointed as alternate director? Well, for listed companies, the restriction is really stringent. Now, for an alternate director, if you are a board of director in the public listed company, you can appoint an alternate director. But then for a written resolution, that has to be signed by every one of the directors. I don't think it is a normal business practice to appoint another director to be an alternate director. I can appoint a director to be a proxy, but not an alternate director. I think a distinction has to be made, because I think for public listed companies, the restrictions are rather stringent, and I think we should abide by those. And I don't want to see the situation where more than one director is appointing the same person to be the alternate director. I don't think it's a good governing practice. Mr. Yu, let me supplement. For these model articles, for the directors' meetings, there doesn't exist a concept of proxy. Proxy exists only in a general meetings. It's just that when a shareholder doesn't attend a general meetings, he appoints a proxy. But for the directors, it's a different scenario. We just have the mechanism of an alternate directors. We agree with what members said, that we don't want more the same person be appointed by many directors and he will make the decisions and all that. This is exactly what the model articles want to prevent. So why do we allow directors to be appointed as alternate directors? Say, if a company has 3 directors and one of them is not available to attend the meetings, so rather than appointing someone from outside, he may appoint another director who is more trustworthy to make decisions on his behalf. So we think that this is an acceptable arrangement. And that's why we have written that into the model articles. Say, if a company finds that, appointing a director to be an alternate director to be inappropriate, or if there are other regulations relating to publicly listed companies, then people can make their options. Now, as for this purpose of these model articles, we think it's appropriate for the director, or it's just allowable for the director to appoint another director to alternate director. Now, there are 2 scenarios that he is the alternate director can be counted as one person only, i.e. in signing the written resolutions and also counting towards the quorum. So if a company has 3 directors, and if, say, the same director is appointed as the alternate director, then the meetings would not be cannot work because the quorum cannot be met, and also the written resolution can't be adopted. Say, if there are 5 directors in a company, then 2 directors appoint another director to be the alternate member, then that will work because there are other members who can act as checks and balances. As what Ms. McKenna said, for written resolutions, we want them to be adopted rather independently so that the requirement is more stringent. So if more than one director is appointing the same person as the alternate director, then the written resolutions can't be adopted. So can the administration write it in clearer terms? Can you spell out categorically that one person cannot act as the alternate director for more than one director? No, that's not what they meant. This is not what the administration's intention is. Now, if there are 3 members or 3 directors in a board, then the alternate member mechanism can work for holding meetings, but not for written resolutions.
So you can only be the alternate of one director, and you can't be the alternate for 2 directors, because we want to avoid the situation where 3 directors appointing one person as the alternate. I think it won't do any harm if what my suggestion is written clearly. Chairman, we try to strike a balance here. Some companies may prefer to have alternate for all directors, but for a company with 5 directors, I think some directors may like other directors to help them. Now, we want to avoid the situation of having 2 directors appointing one director as alternate. I have to say that we want to avoid the situation of all directors appointing one person as the alternate. We want to avoid that because for the alternate director to vote, he may represent the preferences of too many different directors. If companies find our model articles problematic, they may choose to make their own changes. We want to avoid situation whereby you have one person attending a meeting but claiming to represent many directors. Can you go back and reconsider? At present, the way it's written is confusing for me. I completely understand the spirit here, but can you write it out in a clearer manner? I think this is shared by Mr. Andrew Leung. We are not against the spirit of it. We're just trying to ask you to reconsider how it's written. All right, Mr. Yu has already told us the intent behind the notice. Anything else? All the airlines we're supposed to scrutinize have been scrutinized. And this morning, the Hong Kong Institute of Directors sent us this email, and I believe it has been tabled to members. In the email, they offer their comments on points raised at previous meetings. They agree with some points made, and they also put forward some new ideas. I don't know whether members have read it, because the letter is tabled in such a rushed manner. And I think for the previous scrutinized legislation, the administration has already said that they would incorporate our views. They said at the beginning, but for some others, that's not the case. So I would like to invite the administration to read the letter to see what your position is. Shall we have another meeting? If not, then I'll ask the administration to give us written reply, and if members do not agree, so that we'll have one more meeting. All right. No views? Then we've completed the scrutiny of all. There's one more thing. The administration sent us a letter yesterday. 1353-12-13-02. This is the letter. Mr. Yu, what's it about? Chairman, first of all, I would like to thank the subcommittee for assisting us in scrutinizing the 12 subsidiary legislation. We briefed the FAP on the legislative work for the new CO, and we expect in the fourth quarter this year there will be relevant amendments and other amendments on the new CO. These will be put forward to LESCO for negative vetting. The subcommittee in the past year has been running smoothly. And if this subcommittee is to scrutinize the further LNs and relevant amendments in the fourth quarter, it will be very efficient for us. So we leave it to LESCO to see if this subcommittee can help us with the scrutiny of the other subsidiary legislation under new CO. Any views, members? Mr. Sin has just entered. He missed what Mr. Yu said. Paper 1353-1213 has been submitted by the administration. It is about possible work on scrutiny of subsidiary legislation, and the administration asks us to help with the scrutiny of any further subsidiary legislation amendment. Any views, Mr. Xin? No views. All right, then we'll go by Mr. Yu's suggestion then. This suggestion will be included in the report. To the House Committee. I think basically we have completed the scrutiny. I say basically because we still have to wait for the written reply from the administration of points raised at this meeting. And if members are satisfied with the reply, then we don't have to hold any more meeting. If not, we'll have one more meeting. And that's all for today. Thank you. Sorry, just one more thing. We have to submit report to the House Committee on the 28th of June. Yesterday, we asked for extending the period of scrutiny to 17th of July. It was raised by resolution. So the deadline for any further amendments will be 10th of July. If there's no further question,